Welcome to this unit on the Indian Constitution. We'll start by exploring its foundational principles and key terminology. This includes central concepts like fundamental rights, citizen duties, federalism, and how power is balanced between the central government and the states. This foundational understanding is crucial, whether you're approaching the Constitution from a theoretical perspective or preparing for litigation. Let's dive into some key constitutional doctrines, starting with the very significant doctrine of basic structure. This concept originated from the landmark 1973 case of Ananda Bharati versus State of Kerala case. In this case of Ananda Bharati, a monk, challenged land reforms, leading to a massive 13-judge Supreme Court bench hearing arguments for over 2 months. The historic 7-6 judgment, delivered on April 24, 1973, established a crucial principle. While Parliament can amend the Constitution, it cannot alter its basic structure. Think of it as the soul or watchdog of the Constitution. It ensures that certain foundational principles can't be destroyed, even by Parliament's amending power under Article 368. Its main purpose is to protect democracy from potential overreach by a majority. Some of these key elements identified as part of the basic structure include the supremacy of the Constitution itself, the rule of law, separation of powers, judicial review, federalism, secularism, the principles underlying fundamental rights, and of course, democracy, and the limited amending power of Parliament. The basic structure doctrine didn't appear overnight. It evolved through a series of significant court cases and amendments. In the 1951 Shankari Prasad case, the Supreme Court initially ruled that Parliament could amend any part of the Constitution, including fundamental rights. However, this was overturned by the 1967 Golaknath case, which declared fundamental rights immutable and beyond Parliament's amending power. Parliament responded with the 24th Amendment in 1971, reasserting its power to amend any part of the Constitution. This set the stage for the Kesavananda Bharati case in 1973. While it upheld Parliament's power to amend fundamental rights, it simultaneously introduced the basic structure doctrine, creating that crucial limit. Later, the 1975 Indira Nehru Gandhi case applied this doctrine, striking down a provision that attempted to place elections of top officials beyond judicial review. The Minerva Mills case in 1980 further reinforced the doctrine by stating that judicial review itself is part of the basic structure. The Waman Rao case in 1981 clarified that the doctrine applies to laws enacted after April 24, 1973, the date of the case of Ananda Bharati judgment. More recently, the 2007 I.R. Coelho case ruled that even laws in the Ninth Schedule, traditionally immune, could be judicially reviewed if they violated the basic structure after that date. Finally, the 2014 striking down of the NJAC amendment highlighted that separation of powers and judicial independence are also core elements of this basic structure. Beyond the basic structure, several other key constitutional doctrines guide interpretation and governance. The doctrine of separation of powers divides state power among the legislature, executive, and judiciary. Each branch operates within its own sphere, creating essential checks and balances, and it's considered part of the basic structure. The doctrine of pith and substance helps resolve conflicts between central and state laws. It states that a law is valid if its main purpose falls within the power of the legislature that enacted it, even if it incidentally touches on another's jurisdiction. Then there's the doctrine of eclipse, which means a law violating fundamental rights becomes unenforceable, but not entirely void. It can revive if the conflict is later removed. The doctrine of severability allows courts to strike down only the unconstitutional parts of a law, keeping the valid sections intact, provided they can function independently. The doctrine of colorable legislation prevents legislatures from doing indirectly what the Constitution directly prohibits, ensuring they stay within their prescribed powers. Finally, the doctrine of harmonious construction is applied when constitutional provisions seem to conflict. It guides courts to interpret them in a way that allows them to coexist meaningfully, promoting unity and consistency in the Constitution. Now let's turn our attention to fundamental rights, found in Part 3, Articles 12 to 35 of the Constitution. These are the basic human rights guaranteed to all individuals in India. They are justiciable, meaning you can directly enforce them in the Supreme Court under Article 32, or in high courts under Article 226. Their main purpose is to protect individual freedom and dignity by placing limits on government power. These rights are broadly classified into several categories: the right to equality, ensuring equal protection before the law; the right to freedom, covering aspects like speech, assembly, and profession, though subject to reasonable restrictions, the right against exploitation, prohibiting human trafficking and forced labor, the right to freedom of religion, cultural and educational rights, particularly safeguarding minorities, and, crucially, the right to constitutional remedies, which provides legal recourse if your right. Violating these rights can be a punishable offense. While most fundamental rights can be suspended during an emergency, Articles 20 and 21, dealing with protection in respect of conviction for offenses and protection of life and personal liberty, remain active. Importantly, fundamental rights can be amended, but they cannot violate the basic structure of the Constitution. A notable change was the 44th Amendment in 1978, which removed the right to property from this list of fundamental rights. Next, we have the Directive Principles of State Policy, or DPSPs, found in Part 4, Articles 36 to 51. Unlike fundamental rights, DPSPs are guidelines or instructions for the government, aimed at ensuring socio-economic and political justice and promoting the welfare of the people. They serve as a code of conduct for all branches of government, striving to create a welfare state, and Dr. B.R. Ambedkar famously called them a novel feature of the Constitution. It's important to understand that DPSPs are not legally binding and are non-justiciable, meaning you cannot go to court to enforce them. They primarily offer moral and political guidance for lawmakers. While fundamental rights focus on political freedoms, DPSPs aim for socio-economic goals, and a healthy balance between them is essential for a thriving democracy. DPSPs can be broadly classified into three categories: socialistic principles, which promote a welfare state, covering aspects like equal pay, workers' rights, and free legal aid; Gandhian principles, inspired by Mahatma Gandhi's philosophy, focusing on village panchayats, cottage industries, and prohibition; and finally, liberal intellectual principles, which include concepts like a uniform civil code, early childhood education, protection of monuments, and the separation of the judiciary from. Many DPSPs have been implemented over time through various laws and constitutional amendments. The 42nd Amendment in 1976 added important articles related to free legal aid, workers' participation in industry, and environmental protection. The 44th Amendment in 1978 aimed to minimize economic inequalities, and the 86th Amendment in 2002 notably made elementary education a fundamental right, shifting its focus from a DPSP. Beyond amendments, practical measures like land reforms, the Minimum Wages Act, the 73rd Amendment establishing Panchayati Raj, Mgen Rege, and various labor laws demonstrate the government's efforts to realize these principles. A prominent DPSP is the Uniform Civil Code, mentioned in Article 44. It aims for a single set of laws for all religious communities regarding marriage, divorce, and inheritance. While deemed desirable by the framers and supported by Dr. B.R. Ambedkar for gender equality and national integration, its implementation was left to government discretion. Currently, states like Goa already have a version, and others like Uttarakhand, Gujarat, and Madhya Pradesh are actively moving towards it. Shifting gears, let's look at fundamental duties found in Part IVA, Article 51A. These were added in 1976 by the 42nd Amendment and represent a list of responsibilities for citizens. While their legal enforceability is a nuanced topic, they serve as a moral compass. Now let's explore the structure of the Union government. At the top we have the President of India, who is the head of the Union Executive, indirectly elected by an electoral college. The President holds executive, legislative, judicial, emergency, and military powers, and there's a clear procedure for their impeachment. The Vice President of India serves as the ex officio chairman of the Rajya Sabha and can act as president in case of a vacancy. They are elected by members of both houses of Parliament. The actual executive power largely rests with the Prime Minister and the Council of Ministers. The Prime Minister is the head of government and chief advisor to the President, and the Council, led by them, exercises executive power. They are collectively responsible to the Lok Sabha. India's union legislature, or parliament, is bicameral, meaning it has two houses: the Lok Sabha, or House of the People, whose members are directly elected by the public, and the Rajya Sabha, the Council of States, whose members are indirectly elected by state legislative assemblies, representing the states. Parliament's core functions include lawmaking, financial control, discussing national issues, and holding the executive accountable. Members in the houses also enjoy specific privileges. Next, let's examine the judiciary, both at the union and state levels. The Supreme Court is the highest judicial body in India. It has several types of jurisdiction. Original jurisdiction for cases heard directly by it, like disputes between the center and states, appellate jurisdiction for hearing appeals from high courts, and advisory jurisdiction to provide advice to the president. A vital mechanism is public interest litigation, or PIL, allowing citizens to approach the court for public welfare, especially for marginalized groups. The independence of the judiciary is carefully safeguarded by the Constitution, which is crucial for checks and balances. The Supreme Court's powers under Articles 32, 136, 141, and 142 are even considered part of the basic structure. Below the Supreme Court are the high courts, the highest courts in each state, which possess original, appellate, and supervisory jurisdiction. Their writ powers under Article 226 are particularly broad, allowing them to enforce fundamental rights and for any other purpose, making their writ jurisdiction wider than the Supreme Court's. Similarly, high courts' powers under Articles 226 and 227 are part of the basic structure. Finally, we have the subordinate courts, including district, sessions, and magistrate courts, which function under the supervision of their respective high courts. Now let's look at the state government structure. The governor is the nominal head of the state executive, appointed by the president, and serves as a crucial link between the union and state governments. The real executive authority rests with the chief minister and the council of ministers. The chief minister is the real executive head, and the council, led by them, is collectively responsible to the state legislative assembly. State legislatures can be either unicameral, with only a legislative assembly, or bicameral, including both a legislative assembly and a legislative council. The state legislative assembly, or Vidhan Sabha, is directly elected by the state's people, while the state legislative council, or Vidhan Parishad, found in only a few states, has indirectly elected or nominated members. Overall, the state government structure largely mirrors the union's, with the governor analogous to the president and the chief minister to the prime minister. Finally, let's consider center-state relations. India's constitution establishes a federal system, but with a strong central bias. These relations are primarily divided into three types. Legislative relations detail how lawmaking powers are distributed through the Seventh Schedule, which contains the union list for central laws, the state list for state laws, and the concurrent list for subjects where both can legislate, with union law prevailing in conflict. Administrative relations cover the coordination of executive powers, and financial relations deal with the distribution of taxing powers and revenue. A critical aspect here is the use of Article 356, or President's Rule, which allows the union government to take over state administration during a constitutional breakdown, significantly impacting the federal balance. The Indian Constitution also includes emergency provisions designed to safeguard the nation's sovereignty, unity, and security. There are three types of emergencies. First, a national emergency under Article 352, declared by the President due to war, external aggression, or armed rebellion. During this, fundamental rights, except Articles 20 and 21, can be suspended, and the federal structure can become unitary. Second, President's Rule, under Article 356, also known as state or constitutional emergency. This is imposed in a state if its government cannot function according to the Constitution. And finally, a financial emergency under Article 360, declared if India's financial stability is threatened, potentially leading to directions to states on financial matters and salary reductions for government employees. The Constitution can also be changed or amended through a process laid out in Article 368. There are different types of amendments. Some require just a simple majority in Parliament, others a special majority, meaning 2/3 of members present and voting, plus a majority of the total membership in each house. For certain federal provisions, the special majority also needs ratification by at least half of the state legislatures. However, as we discussed, Parliament's power to amend is not absolute. It cannot alter the, quote, basic structure of the Constitution. Several amendments have significantly shaped the Constitution, such as the 42nd Amendment in 1976, often called the mini-Constitution due to its extensive changes. The 44th Amendment in 1978 then undid many of those changes, notably removing the right to property as a fundamental right. Later, the 73rd Amendment in 1992 constitutionalized panchayats. The 86th Amendment in 2002 made elementary education a fundamental right, and the 101st Amendment in 2016 introduced the Goods and Services Tax, or GST. Finally, let's briefly cover local self-governance and the schedules of the Constitution. The 73rd and 74th Amendment Acts of 1992 were pivotal, granting constitutional status to panchayats for rural local governance and municipalities for urban areas. These amendments established a three-tier system for panchayats and laid out provisions for their structure, elections, seat reservations for disadvantaged groups, and the devolution of powers. Beyond the main articles, the Constitution also has 12 schedules, originally 8. These schedules contain additional details on specific aspects. Key ones include the 7th Schedule, which is vital for understanding center-state legislative relations by detailing the union, state, and concurrent lists of powers. The 8th Schedule lists India's official languages. The 10th Schedule, added by the 52nd Amendment in 1985, contains anti-defection provisions. And the 9th Schedule, added by the First Amendment, initially provided immunity from judicial review, but as clarified in the 2007 I.R. Coelho case, laws placed in it after April 24, 1973, can now be judicially reviewed if they violate the basic structure. Thank you for joining this overview. Welcome to the